For another, Yawaha and the appeals court acquitted and discharged convicted Sedinam Tamaklu. Why am I using convicted Sedinam Tamaklu? And it said, on April 16, 2024, a leadership justice Efiasewa Asaributri, the High Court judge, Mame Sedinam Tamaklu, abo on minor chrono, and unti Mami Onko and Konkoshe Efiase 10 years. Now, Mami, right after so Baby Drew my Ghana under FBI for extradition, Nebi Kasa Mami dear, definitely on good jail, on Koshe prison, Empo ND 1 month. Yebe Kaya, Fifi Buafo. Can't same way. Now, if you go off a bill, will be a bono, and I did a brand or can some message them Tamaklu, own child even 1 month, prison, and okrenso abemonra. Now, and then on my in your dubachi, Edin Sembi air to abonting. You are putting in common. Now, Sunny lawyers been so edited and come off home. Say, Yebe Kaya, Ebusian. Honorable Amia Okumfi. To see, I'm not say, or do court Akonia Bassa about a skyline. Some contract, next case costing na $2 million. One team ye, see I'm not say NDs are buying a transfer any basa $2 million no. Now you have $200 million. Honorable Collins Dauda Sagleme housing project no. Also ye no kukwasa. Buying us $200 million no. And you the topmost priority and ultimately to also or filing null press required Emma but Sakis no uchem. And on concordant $663 million kwabnando for so not just also involving a so or minor cast $663 million no. A binary so assign a trasa case in him. But $2 million now involving honorable Amia Confide, a binary so interested. A camera quest a buy winning Crofobia Mujina and Branano Biano or bar no chai warm. Not just a MPP Nibisu Somokadia any day in and day out. Not just a almost Chinese Renibas or Mubia, no, Akofa jail sentence, Kasibi, Eddie Amani, every to chama wound to me. In fact, and all my name Akasapa and some of the Boo Aponoso and Anope.
Say the prosecution could not establish enough evidence based on criminal standards.
Yes,
it's Jano.
I say, Mammy, baby, so bed them, want them, or buy a bed fire, I was
listening to Waffle.
Yes.
Elwood TV3.
Yes.
He said emphatically, say, this woman will not spend 1 month in jail. He will be acquitted and tried by the Court of Appeal.
Yes.
Moka say, what preemptive and then anybody.
Yeah.
Anybody. Now the issue is this. So what to me catch them say, Collins Dauda, Saglemi, Ubia Nitia, says he carried him almost so see 5,000 housing units. 200 cry. Yensi. Sikano swa. Asa.
Ye dear manasa.
Siwe jaya betumi yama any electricity betumi 200 ne cry ni pako tremuno. Eye watch bidi. Ya kase abayi ni si wonye interested. Si wabako akwaji $200 million. Nemo obi 1.2 million. Ojina court. Skyline eye $2 million.
Yes.
Ayi papa edi say. Amia kumfi. Agent court 2 million 200 million in
about 2 million
663 million involving Dr. Kwabrando for woman in trans say on tier 60% and who say baby obi anti arrangement na say and there ye free court.
Yes.
Oh, so when you do this you don't come and tell me say you are fighting corruption.
And I got
what is corruption?
On my way, Emra.
The money here.
Emra say.
You said the High Court here, appeal court, Emra. Omujina Mraso.
Emra.
Emra, what do you say? Comment, sir. My argument has been a pacho. My argument is say, Omujina Mranoso. Adia bia
I understand you. Listen to me.
Constitutional. So,
Adia bia ni mama buy. Enyamra kwanso no pamo tokunu.
Oh yes.
What are people saying? Enyamra kwanso and the wama judges justices of the Supreme Court what the ensuwa keka ho.
Yes.
A good for the time. Omo de omko enyina no obi free hard with the shape. Even that one. Omo pedi your mama complaining. We have almost 69 judges are ya packing to Court of Appeal and High Court. which under normal circumstance yenya ne sa
yes
say yesua judges ko gum sa those times Akufo-Addo appoint bia ya na wo Ghana dey asem na no man pani joma man
we call retirement we say we are
but there is moral suasion
yes
there is conscience nada you betimi de obi ato bibia dia na say nipa no ya ye mbra de na to but utie judgment na ye di nipa no to na it doesn't make even constitutional sense but it make judgment say
o my dey me can no me say
what are you talking about?
Me say, Mran, they look into the face of the law. And to say, democracy, and I say, then we complain. We press won't to me, say almost appeal or never. Namia near near Jana, it's the same law.
Muntieta,
how mighty.
Or Massam see, or my penny your mama. Do you know it was one of the bases among Ghana for be crowded before to Abetiano?
Oh yes.
But and then presidential pardon or the mao.
Yes, yes.
Oh yeah. Over to me Jinamra so I near but one thing you understand is and they cannot cry genuinely. It's the society in Ghana. Ghanaians happy see David. And to say court to no say one for evidence hammer. They are saying say okay. Asante, you said unanimous 11. I say
unanimous FC.
Unanimous FC.
Yes.
Oh, meba. And your man, Penny, your mama, the kind.
Even
the Quran, the judge.
Oh, Debbie.
And Yemra. But why was the president angry? Say, I debut on the baby, I know almost say no. Now, unanimous FC. I didn't tell, I know Yemra.
Oh, yeah.
But in yes, I have no kai.
Oh yeah.
Now and then no judgment our baby. The Chief Justice ruling beyond the bar say he Attorney General. OSP bet me I prosecution. They mum say oh articulate it out to me. So odi asem na wani nyi ho abetima court say sa asem no unye interested bio at to chat. Wait what say what ojira so na am ruling. But our conscience is telling us say now our justice system is so skewed.
That's true.
2024, NDC was so much on the justices about Mraya di Bumaino. Say, ya buntenchia chia. Wait to no be so can we idea some Nabeka. Library Yamwachi.
Yeah, man.
What are Roma? And someone be told ya a far court of appeal, some of the 2J, a grounds of which now saw any and some Ghana for in a cano. What are my way a lawyer ni a back constitutional law would dim one court pa. Court of appeal ruling out the abbey. What can I say?
And some really informative say, oh, to know, to be a some run. Let me say, in such as I've seen one and we see. So I wasn't surprised. In terms of almost filing 2024, I'm filing appeal no. I'm filing appeal no. I'm yet Ibia copy say na say February no mo trust say court more kwan na I'm filing almost submissions because na pa. Na court more kwan which is done. Until July ya no appeal yet right for hearing. In less than 3 weeks, judgment aba. Because I need you, papa muno. Say judgment the quiz the new say cases check our court be brave. But with the speed that that case will buy in there, a novel. The bumpire say court no. If we and say and echo, say no move answer. True. Court say about 30 or 34 of the charges no the more Sedinam were defective to almost striking out.
Okay.
Mind you, charges was about 78.
78 counts, yeah.
Until the akano. No meaning an almost prosecution and to me improve the case and no beyond reasonable doubt. Mama. Me judgment no being kind fully just snipers that even I video online and I'm not carrying. Into the court na bank say acquitting at this time, you know. So on the same facts, you know, nobody can prosecute her unless just an appeal. This will be as a full there. To say no, Skabia involved Biano no, or minor friend. Cause what a patch say, we need Skabia on fire, buying Skabia on fire, Ghana Skabia, whatever amount involved, no song, to no punishment, to no recovery. That is what we are confronted with now.
Now, Eba say for 5 years, and I'm no general court. Witnesses be brave by and crata same yina by. So what ye mamia or turn gem a final conviction of verdict by ya. Now utie nin some more can ye describing the ACN as daylight thievery, normally words or use ye. Se chrono ankasa se chrono techi amwana ya ball mine on the idea. Na appeal court to kase the omoye nyina mfie with all the investigation ni ade nyina no. Omantimi anyina bibi papa bi so enom de maame ni tumu to magya no a. What does it tell our justice system today?
It's becoming a trend. Who's the first man who can be so? They're not police here, Virgin police. Now, baby, I know my shift. They don't play. If you not crown and say, Chris, how could you say? Yes, what could you have to know? Now, some of the back of firms just would do. Could you do? Like, from my vice president, by the time I was a question and prosecuting. But most of the people know you're not, yet you're moving, I buy a tissue and call for. So, is it strange? Is it not strange to say? Oma about we support man and some support party in power no. Now they are getting favorable judgments. And maybe a trend in constitutional cases may idea by Supreme Court to do unanimous FC no. What has happened? I didn't know more unanimous FC or what was happening in the judiciary. Now if you say now the judiciary is not bold because Ubia is scared. First, they were insulated, but once the head or the civil was removed, I'm not. That is no. Now, you know where I cost I don't know the motivation and all the right is, but you may not like one person or the other, but judgments are no. Law, no, sometimes women's work alone, but not for the idea. If he said, I was say sorry now, yes, so say they should be both as it has been. Because with that my crown, Judiciary, was there and was bold to face the military rulers nearly. Why now? Now it's like, okay, so who are bonus or somebody and here? Women say you are sure of going. Whatever it is. See, that is real. Supreme Court crown my judgment against EcoBank and the interest rate they awarded it was inexplainable. And I will see in fact, now the law is not certain. The law is not certain again.
Abusia for Oman any lawyer Brinya and I say you could see no. Now Abusia Obi no. And Oman sign Ebisa lawyer Brinya or your private legal practitioner he say. Sisi a ye kasa wo Ghana he say e kame akoye say ye be kaya emra na NDC amanyuko ewo position John Dramani Mahama himself o say adan a na na do Akufo-Addo apaki Supreme Court ho with eye MPP judges and I say yes MPP judges and akwakogo na eno nti oto mu din kura from eye unanimous FC John Dramani Mahama e kan bi enne sisi a me na say wo ye MPP ni na say wo kokoto a wasemba na say wo kokoto a fa she utrim say wo ye dai wo bedi for any saying judges are a woman na one a NDC for. Say ye be kaya na Akufo-Addo time. Empo se no be appoint obi de na ko a bench no so a. Na ohwe se ebinom afri mu akɔretire. Na so ne die nipa no mo retirement kra na just say sign e de foforo ekwa kopi so e wo ho. Ye say aban we buy no wa chese wa pake NDC judges and akwakogu a Supreme Court or any the High Court or any the Appeals Court. I just abusia wa semba na se kokupi mo de ane ne fansa guti de besi bia no ho ebeka eno enene lawyer brinya ene oman hini din komo no mo chese se de ye justice system no in fact e totally skewed because who ye de wo koi se okita evidence kra na wo duru kra na judges tisu nyina no automatically politically wa ba be your mo enemy enti wo kono ye din kan kra buafo ansakwa na wo kwakopi wo no manim e wo court wo no in fact ene lawyer brinya esan edin semu we to dwa e kire oman hene ya adubuache e wa bre na mo twetwe nkomo e fa Sedinam tamaklu acquitting and discharge at say the appeals court edi amano no yetie ensem a wonom e kaka ho ene anope
eti ama lawyer for obeka se mo court a evidence nom ne niema nka bia ogina so say case we mutumi edi monsasi so say sa case we dey based on this evidence and other thing edin kunim no ama mo sa we write mu notes ana.
Yes, okay, and I quite in this here. On Sunday, Yeshua said, no, this is it. The law is on my part because anything can happen. Now it's like anything can happen.
Eba say ya, Emma, GDA war a justice system, no, a co form ana acquire political talk, and ebia maame no so na court of appeal so hwehwe mu no na nukremuni political prosecution binti na bi omo so agya no.
Okay, so let's start from January, February of 2025. Why is it that Attorney General FRU no prosecuting all the cases involving the NDC people,
okay,
who were in court being prosecuted? And why is it that all the people who have been arrested now are NPP or they are people on the other side? That's the first thing. The second, you say, the court no is not to be is not trusted again. The standard has been lowered. They are not this, and then they even then encourage some certain lawyers of particular political divide to go on the bench. Okay,
yeah.
There's a meeting in Hope where this statement was made. And now we be a convention. Will be our baby or supporting the but with that encouragement, then what exhortation, people have joined the bench. And now judgments are being delivered in a certain way. So it was also safe to say, and yes, I said, I can't we say so, Basso. And the promotions are banning idea. The seniors maybe which is a high court, at the juniors court of appeal. Promotions. And then we have to also promotions. Sometimes, okay, I didn't add also Supreme Court with the case of OSP. Will be a Korean to say only to me say you would his back. Abana some Supreme Court agent determining here. The Supreme Court case decision is now void. So what here?
Yeah.
Yes. So they say that is maybe pro will be I might say members of parliament I don't want to catch the eye of the president for appointment. That is the idea this no the brain so yeah. Because be pro yeah nema sabe among some politicians are more you hear to please the powers that be for promotion and all those things. And see, that is what is happening now. Because many people here and seeing him. But the other year, my young son say, come on, you try the prosecuting Dr. Punumuni, I don't know. But cases, now they are insisting. So that has given a warrant for those judges to sit to do in the vacation, which is leave time, total leave time for lawyers near the year. Now, what clients you're prosecuting? Yes, on my court, one quite you make what 2 months and to lawyer know the time now crab. It was waiting but report you have a form day you got a case by then. It's good because the work is stressful. This is the only time I will find a job home. Now lawyers are being compelled to come to court to do the vacation because they play who do something go far tomorrow, whatever it is. It's very serious.
For and 70B and I could see now in fact and then on my and I will for SIA can be say John Dramani Mahama, so corruption now castle Baba fighting, and on our fight here and answer the bay. Ekana kwese se we NDC ni na se ubo man no krono nko ana sa ban wa ban ba NDC aban ba nko ade a ubenya uti edidi it John Dramani Mahama wo se twa ho be ka kire wo appointee ze omo hwe omo hu yie na omo ammo o man sikam ana so man fom san ko bo man sikam no eye na dancing bi ama be ka de a kire Sedinam tamaklo de obi anim say high court ahu se maame no wa bo o man no krono ayenye krono ketwa charges e de to no so na nyisika ketwa wo ana se men kan se charges e de gu no so a akwadu de ball no high court de ball no ama mi bibia da de pefie no na enyensam ketwa ene de appeals court e kire say omo enhu enyina so bia high court no fa so e di gina so a wode a sentence maame no 10 years into prison aden maame e reject check payment Emma later on or sign a request is on first economy on table. According to report, just say Mumpokrano, Ediku, a funeral swami musicani allude in funeral swami mu, Ediku Shiama, me Sedinam Tamaklu, and later on or sa a divertis scan educo on one personal account. Abusia, and then the appeals court is telling Ghanaian say, Omunim and Yinasu Pion Befasua, or maybe a bit jelly ma, and so on, serving the 10-year sentence now, high court at the Emano. Not just say, O minor, in justice system, no, it is totally skewed in favor and crophobia, especially NDC Aminuko, so Muba Bema, or Munipebi or Mujina trial Biano, not just a one quality at discharge on so Munko, Nomoka one and in fact, or my hene Akasapa, NT said your cancer with a farm.
In all this winning, you know, me say, Satani General, and say, Oko Faliday. State of execution no say or appeal. Nemna court of appeal in transiano. Our more frasem no. E the argument. The asem no ko catch the court no. And no court na ntia. Court na di asem na di etia no. And they also court Supreme Court akwa challenge the decision of the Court of Appeal. Ade bi ko viral wo ade no so Yagris betimi de ato so a omo a highlight response awo Attorney General no wo de call court no mo ya ba ku bi na me de ama na ye de yellow afase no pacho de to so ma me a kebebo me pa yes akota kayade we
wish to bring to the attention of this honorable court that the record of appeal before the court is not complete.
Yes.
We state that all the exhibit tendered by the prosecution during the trial does not form part of the record. The only document found as part of the record are some of the documents which form part of the disclosure done by the prosecution. But as it may, we have had to proceed with our submissions relying on notes made by the prosecution. As we, okay?
O Attorney General no wo na o prosecute two maame no whether eyo na wo oho anase woni honom no wo na wo prosecute ye it wo na wo de adanse call high court emi jeli maame no obi afile wo court of appeal or file for court of appeal or court challenge decision e de ma wo no also won krata na nye complete inti ye gira asante ebo a woni na nya asem no ono no niam so ene ye de na wo ya be ka kire say ena me call akutade we obi ba bia wo transidi na already some of these things
you know are cosmetic.
I say ebasa me dey me worry you know say
the very first day
Attorney General na asem na wo kan
yedi Collins Dada asem yedi Johnson Siama yedi opuni no masema obuka say ehia omu bio na wo so gitum say wo ye NDC ni na wo hosisia ade a amompani kan na munhwa mu ye na wa obey mranu no bedi no it is only a funtus official, it is only a faux pas
akuta Attorney General omo aye
ebasa wo ye NDC ni a onye emboldened now.
Attorney General no mo yen kakra eduru ba bia yenya lawyer for yenya judge for mo na mote mo mra no ne mo ho ahwan no ase ba ne ma ne bi wo ho no mo ase me ordinary Ghanaian no me kenkan ni se ya na me ni se na fe mbisa se na wo Attorney General no na ade obi kokko na de say yen eti wo san kata no
amato agu ana
yes no way what ba wo de wo ni bi udi baka ko jira
so those cases no on vanya omo
ne ma ne bi wo no my hardwene
right.
You mani be biro hodo mo e hadwene.
Me de mase.
Omo na tu omo mra ase.
Sesi a Ghana hanomo. Wo ye MPP ni na wo hono na wo aban mu a you ready. Omo hwe oni ma mu wi ade come for you. ɛne ɛkɔɔto no nso obɛgya obɛhyɛ ɛne wa wogyegyirigye ɛno ano sɛ metra mebɔɔ nnipa bɛɛ nnan bi a wɔn mo nsɛm ayɛ ready yɛbɛkye wɔn mo de wɔn akɔgyina hɔ NDC ɛfiri nnɛ ɛkɔpem sɛ 2029 galamseyfoɔ yɛabobɔ mu din yɛsi wanwan you will not see anyone in court
ɔrakɔta ɛba saa so so a yɛnkɔ yɛno mu sɛ yɛdeɛ
court no yɛse $200 million sakrami obiara nim ho asɛm yɛse Collins Dada ɛmɛyi na no wɔde ne submissions ne biribi akɔ a asɛm no yɛdi o aban sesa ya Attorney General aban tiemio Attorney General wɔyɛ aban futufuo wɔ sɛ obi di Ghana sika ɔno na wɔso ɔkɔgye sika ne ma yɛ ɔse sɛ sika no wɔnyɛ interested
Sedinam trial ne hyɛ aseɛ na woyɛ Deputy Attorney General, right?
Mebe toso.
Oh, ba toso.
Abra na penka
okay. Okay. I mean, sir, Osha grounds of appeal now. The first one was the charge sheet was defective. And you would realize the Court of Appeal ABC or decision mainly on that first ground of appeal it was saying, I mean, a defective charge sheet and answer then.
Yes, Court of Appeal judgment you are right. Say rely on defective charge sheet. But the big kind say I disagree with the Court of Appeal. They didn't do a good job. Judgment not stand the test of any legal scrutiny. Now, the match
okay.
In your lawyer media, lawyer media would see me. The ample for argument's sake, the charge is quite a defective one. And just what the Nipano Ujano by the appellate court. May come Remy, citing Remy, Section 31 of the Court Act. Check 31 and 31-2. Now, said the Parliament in Maxwell, Omutroyo, Omatroyo said, the Court of Appeal, as any appellate court, a will be on the ground, say, charge sheet a defective. Provided, say, miscarriage of justice, MIA, and so evidence, BIA, any record, HSA, Nipano, before. So the Court of Appeal is faulted firstly by Section 31.
And it's your considered opinion, sir. When they establish a charge sheet very defective, no, what should have been the decision? Sir, they order a trial de novo, and now
I'm coming there.
Okay.
I'm coming there.
Okay, that's fine.
So the first time I say be a charge a defective, no. Next phase, and say, oh, she say. Adansia a warm crata so a adansia it me support to any other charge as you have it now. And I am pushing your catch them and say, what was work as a charge a defective one? What you do is say you order trial de novo.
It should be as a for
exactly. Because Ebasana is on technical ground.
Yes.
So, because we are talking about 90 million Ghana cedis. And I can't want it. But I will say, cash sheet, defective. So that's the first point.
Okay.
Second point, now a dance here, court anymore, court to be boon any fast one, and a dance here one could be evidence. So I say, judgment, a dimuana, make I say, amen. The kind 500,000 Ghana cedis, I can't say, must look for the command, that institution, or Ashanti region, no. A dance here, the court, and I say, Emrasa microfinance company in cash the cano. Omu say interest was no moon to be chia. Domi some more the checks. Ebra Maslok, Mamma Temaklu. Now send it to be out for 3 years. Mamma said Debbie, on a board chairman, no Casa said Debbie, me near cash. A dancing American to be near what dancing. Yes, our cash no bank that institution is cano cash at the bar and kind. But you'll be sure, Mamma, no more. There's a filling station, Barcelona, filling station. There are dancing, Sahono Mushiano.
Okay.
And on this cano, a shannon said. Then I'll choke that and a sarcas cano. But the sacred scano were found commerce lock accounts to be. It bring your dance and judgment and I say, I think a dance via anyhow. So that's the first dance solid. Unless say, could have a patch and say, I can't dance there, my Jesus Christ, if I am a quarter any dance there. Solid a dance here. Number 2, a dance here, a one craft as well, she said, Mammy Tamaklu, and Mra, a jar a shake and tamanto. Omampani Mahama Samre 2013-2014. A castle mining first time master for, na says cano, umfankoma, get the 4 mano, and show me omugum. First can similar wrong at almost 1.4 million Ghana cedis. Audits na, investigators, it shows say, stand the core man hono, close to 700,000+ Ghana cedis. Almost 600,000 or 7,000 there, can uncle money be out. Then we are dance here, report no at the court farm or so. Number 3, Maslow, say, sensitization program from a mana, discuss from Hono, about 80,000 of them throughout the 10 regions, 10 regions organized. And on budget close to 1.8 million Ghana cedis. Mami Tamaklu, eco region and Sape, out of the 10. Yes, so called yes, it's called spending per within 1,300, meaning I maybe 13,000. 1,003. So meaning almost 1.7 plus million Ghana cedis, no, and also of fire. Another one, we are financially trusted for more clients in the don't buy 246,000 Ghana cedis. 1 year when you can spend even 1 cedi out of the amount, 1 year program na nipani biya. That's kind of what's go back. Do you dance here a walk in Kratemu? And the last one, almost talk has be 350. Yeah, the dance by a car can in a costo pano a $10.something million. Now so we have $14.5 million. Yeah, a dance here and the sun in my room. Now the same a mama cranny say. I dance here the bay more do you know, Mamma no United say on my court, it mean and say I deal with it, and you know, still it here. So on what basis would the court of a PC say a dance here in this assembly? A year, my question makes also opinion that can so when I know correct, Mr. Scanner by the Koha, the winning Koha, then that is all 2 sides. Minister criminal prosecution, the state must produce prove his case beyond reasonable doubt. But on the side of the prosecution, I mean, I can tell you without any equivocation, make Kansas City said the state prosecutors are a Juma we know, Juma Padi tells me the man we the public servants are investigators are more yoku. The kind of Juma Muye or Sadia we move, auditors a Juma Muye, don't be a dance or court. The other court to Ghana like court of Bika say, a dance anywhere. Like I say, idea maybe 2
But lawyer, even before Saubeba, the whether the charge sheet was defective and also defective, no, on even the evidence, no, and the probative value according the 2 evidence, no, the Court of Appeal in Omu conclusion page 92, 93, and 94. Mintiming kind, and I'm only taking a cursory look. So I may share conclusion almost say. Paragraph 120. It has long been the golden thread running through our criminal jurisprudence that the prosecution must prove the guilt of the accused and that this burden never shifts unless the enabling statute or law has expressly and clearly said otherwise. The principle articulated by Viscount Stanky in Wilmington versus DPP, our law student BN, say, and unshaken sense is not a technical nicety of procedure. It is the constitutional expression of the presumption of innocence, and it is owed to every accused. 121, I'm going to say, the learned trial judge lost sight of this. Confronted with a charge sheet drawn mostly in negative terms, that the appellant had acted without authorization or without due process, she reasoned that because the prosecution had averred a negative, it fell to the appellant to prove the positive. That authorization, process, or justification in fact existed. With respect, that reasoning inverts the very principle it purports to apply. 122. The manner in which a prosecutor chooses to draft a particular offense cannot, of itself, relocate the burden of proving an ingredient of the crime. A negative averment, artfully or carelessly pleaded, is not an exception or proviso. It's not an exception, a proviso, or a statutory defense. It remains in substance an element the prosecution must establish, and the difficulty of proving a negative is the prosecution's difficulty to bear, not the accused to solve. I will go further to emphasize the principle that unless a statute plainly places the burden of proving a particular element of an offense upon the accused, she is under no obligation whatsoever to lead evidence in aid of a prosecution's case that has not yet reached the threshold the law demands of it. To require otherwise is to ask the accused to complete the prosecution's unfinished work and to convict her for declining the invitation as was done by the learned trial judge. The prosecution's evidence on a fair and unaided reading fell short of proof beyond reasonable doubt. The shortfall was not made good by any burden properly resting on the appellant, and the trial judge's misdirection on this fundamental point goes to the very root of a fair trial. For these reasons, therefore, I am satisfied that a conviction and sentencing on all the charges, including those manifestly defective charges, cannot stand. I would allow the appeal and set aside the appellant's conviction and sentencing on all count. In the way and a Justice Emmanuel Ankama, I'm not sure this lead opinion, one, the evidence he believes said you couldn't prove the case beyond reasonable doubt because that it was for you to prove and not for the appellant, to rather prove positive. When you crafted the charge sheet in the negative. Okay, counsel.
Brofo, what kind the judge misapprehended, misunderstood the import of the prosecution's case. With a great respect to the judge, his appreciation of the burden of proof, wrong. In criminal cases, the state or the prosecutor is supposed to criminal cases. They'll say, there are some courts, if you prove a case beyond reasonable doubt.
Yes.
Everybody knows this is not something the judge should lecture anyone.
Yes.
Now, prove who we are, then the accused person will have to just raise doubt to show, say, the okay, no prove beyond reasonable doubt, something that everybody knows. So, before what you know, to me, it does not answer the question. The key question is, charge sheet that the state prepare, you must get evidence to back the charge sheet that required. The advance here I was a state no the advance and by my minus crata of sign say scan magic cash a free more. Nipo discard no back or Babisian Bachuna filling station and can manage it cano. Accounts on prepare and issue say one first can for two company with the accounts room. If the get up a before Kaina meaning system manager no Bofon Kataswana. No, that is not how the law works. With all due respect, the trial judge, a very good analysis of the judgments. I mean, you can judgment now, the first one judgment now. To the extent say, or evaluate the evidence, Mamma, a question which a lawyer and or consider it, including Mamma, the statement or the police or consider it. So the judge, the court of judge, is telling us, if the accused stating proving case beyond reasonable doubt, the accused person can say, I will not speak, and then the court will acquit her. No. The court can say, you have a case to answer, and you do not answer, the court can go ahead to convict you. And before the court will say, so, case to answer, no, the court must be satisfied, say, there's evidence on record. So the greater respect to the Court of Appeal, they grossly erred. Even, almost talk about a charge sheet, say defective. We had when already here now.
Yes.
That some are defective. And so what? Section 31 is clear. Section 31 of the Courts Act is very clear. Section 406, subsection 1 of Act 30 is very clear. The Court of Appeal got it wrong. The trial judge got it right. But Court of Appeal has 3 judges against 1 judge. The Supreme Court will have to step in to see, because this particular judgment, so much as dance a woman no any dance meet the threshold, and it's what was called a friend and coupon and comedy dance amount. We are no magicians, but every single ingredient here can be no state in terms of the catching of the chances they will be in the negative or positive. Whether negative or positive, the state must prove its case. So it doesn't matter the language. You are supposed to lead evidence which you say the war cannot prove. We never said the same. I'm proving innocence. The Court of Appeal, they should also know that. You also know. Then no, the state never says to them, "Mama should come and prove her innocence." That's why the trial judge evaluated too. I mean, if you look at the Court of Appeal at the abonnent page, go to a trial judge judgment, not a 94-page judgment, and then look at the analysis for making it against the Court of Appeal judgment. To me, plenty English, but Ghana for a seeker over 90 million Ghana cedis and a Court of Appeal. If it's technical grounds, because then we can be Simon. Empo, the charge sheet is defective. A court doing substantial justice, and a court minded to say also a protected state resources. Say, I'm deciding you go back so that the matter can be tried again by the court.
In the then no on acquittal or better discharge. Yes, because
that's on 30. So if for court act and I look at the court act, how would you put and in the
maybe section 31 of the Court Act.
Yes.
Appeal in criminal matters allowed on substantial miscarriage of justice. I don't know subhead there, no. Also 31-2, right?
Yeah.
31-2, good. 2, they say the court shall dismiss the appeal if it considers that no substantial miscarriage of justice has actually occurred, or that the point raised in the appeal consists of a technicality or procedural error or a defect in the charge or indictment, but that there is evidence to support the offense alleged in the statement of offense, in the charge or indictment or any other offense of which the accused could have been convicted upon that charge or indictment.
Okay, you the whole plane. So Court of Appeal telling us this section no and I mean yes, was section 406 of Act 30 so 4061 bit me here no so.
Okay.
So as a lawyer, speaking as a lawyer, I can say the Court of Appeal has done a great disservice to the people of Ghana in this particular matter. They seriously erred. Our judgment cannot stand the test of legal scrutiny. A combination of whatever the judges think should be the case, but looking at the evidence on record properly so-called, the trial judge, the judgment, and as a Ghana point, I say, I will be speaking as a politician, as a party in that case. I rather urge people who need that kind of thing. So they should take the judgment of the trial judge. No more Court of Appeal, no more